and chairman of the Human Rights Commission of Sri Lanka. So we have, as I said, a very eminent panel. We have a bit of a time crunch, and my apologies for that. For a conversation this important, one would have wanted more time, but such is life and scheduling imperatives. So uh, I guess the first question, the first person who I'll ask to speak is Irfan Qadir Saab. And because when we talked about, and this has been part of our public conversation, when we talk about conflicting judicial decisions, the inconsistency in outcomes, which for sort of, for a view of law, which in my view is perhaps not accurate, but it is that, essentially you apply the law to a set of facts, and then the rest is scientific and predictable. So in the Pakistani context, the challenges that we've had with this, and particularly in a federal context, particularly in a context with in the polarized space that we operate in. So I asked Irfan Qadir Saab to start and speak. And
Bismillah ar-Rahman ar-Rahim. My fellow guests and ladies and gentlemen, today's topic, eroding the rule of law, conflicting judicial decisions. This topic has been a great concern for me most of the time, because for the last so many years I have been dealing with this kind of conflicting judgments, and today I got the opportunity to speak on these conflicting judgments. The topic itself suggests that there have been conflicting decisions on similar issues. The legitimacy of the judiciary was undermined by such conflicting decisions, and the judges were rewriting the law and the constitution. The judges were creating their own law so as to legitimize their illegitimate decisions. The mess created by these conflicting judgments was an absolute embarrassment for the entire system, especially the judges who got themselves entangled in such exercise. I have not used the word judiciary because we should not undermine the judiciary as a whole for the conduct of only few judges who rendered these conflicting decisions. But through these judicial decisions, they did brought the legal order of the country in a very difficult situation. Everything went topsy-turvy and situation became very chaotic as far as the legal order was concerned. Most of these judgments had one common feature in them, and they were based on endless hair-splitting and were unusually lengthy, containing hundreds of pages, and all this was being done to give such judgments some semblance of reasoning and legitimacy. Otherwise, these judgments were outrightly unconstitutional and could not be justified by any stretch of imagination or extensivity. This is a very sad state of affairs as far as Pakistan's judicial system is concerned. However, the generality of decisions in cases coming before the judiciary in the hierarchy of courts do not suffer from this malaise of conflicting decisions. Unfortunately, the delays in court system undermine justice, since justice delayed is also justice denied. Although, as regards the generality of decisions, conflicting decisions are not to that great an extent to which they are in the matters where there are political repercussions. So the role of as I was saying this, the conflicting decisions have mostly occurred in the realm of those matters which have political repercussions. I would thus confine myself to these decisions only and would not touch upon other areas of such conflict. Although the overall performance of our judiciary has been far from perfect. The role of judiciary in shaping Pakistan's legal order, because if we need to comprehend that what chaos has been brought by these conflicting decisions, we must also understand the role of judiciary in Pakistan's constitutional history's perspective and the role of judiciary in shaping Pakistan's legal order during times of regime change has been a consistent feature throughout its constitutional history, spanning over 7 decades. From the landmark Maulvi Tamizuddin's case to the judgment of 31st of July 2009, the judiciary has played a pivotal role in safeguarding the interests of new regime, often invoking the doctrine of necessity to legitimize its actions. These judgments have primarily aimed at protecting the new regime as well as the Chief Justice and his judges. The invocation of the law of necessity has become somewhat of a ritual in these circumstances, serving to validate the actions taken by the judiciary in support of the ruling authorities. One notable departure from this trend is the case of Mian Nawaz Sharif. This happened in the 90s, where ousted Prime Minister was restored to power. Now, this was one decision where judiciary went outside the ambit of looking after the interests of the ruling elite of that time. And here we see that judiciary rendered a decision wherein the Prime Minister was restored, but the impact of this decision proved to be short-lived, as both the Prime Minister and the President eventually had to resign from their positions. Otherwise, in all the decisions of this kind, with regard to change of government, with regard to overthrowing the government, with regard to new governmental order, we find that judiciary always stored the line of those who were to come in power or who were in power. And this was one decision which many people consider was independent, but how much independent it was, obviously there are lots of ifs and buts in that decision too, because there also judiciary was guided by certain extraneous considerations, and it was again not a purely legal decision having regard to the jurisprudence in this realm developed till that time. Despite the significant role played by the judiciary in these matters, it has often come under scrutiny and criticism. The judiciary has been held accountable for its decisions, with questions raised about its impartiality and adherence to legal principles. In essence, the judiciary's involvement in shaping Pakistan's legal order during regime changes reflects the complex interplay between law, politics, and governance in the country. While its actions have at times been contentious, they underscore the judiciary's crucial role as a guardian of the Constitution and rule of law. I must here very candidly express myself that as far as judicial role of judiciary calling themselves to be the guardians of the Constitution or the rule of law, thereby giving an impression as if judiciary is the sole guardian of rule of law and the Constitution is not correct at all, because the role of the executive is also very important in being the custodian of rule of law and being the guardian of the Constitution. And Parliament, to the greater degree, is the mother of all laws. They are also there to guard the constitution and the rule of law. So judiciary, as some judges claim, with some feelings of megalomania, that they are the sole guardians of rule of law and constitution in Pakistan, to the exclusion of every other organ of the state. This perception, the law wanted to empower more judges, or rather the Supreme Court, to constitute benches, but the like-minded judges thought that this was against the independence of judiciary. How could anything be against the independence of judiciary, which empowers more judges rather than one Chief Justice? Because Supreme Court consists not only of Chief Justice, it consists of Chief Justice and other judges. I mean, these were blatant violations of law, which do not require very lengthy reasoning, which do not require lots of references from law books, which on the face of it was illegal, and this was most unfortunate. And then we come to a very recent, for others to follow, and especially if Supreme Court has given inconsistent decisions, the impact is always felt by the High Court and by the lawyers, and it becomes a very difficult area for the High Courts to take a decision in a matter where there are conflicting judgments. Now, these conflicting judgments are many, but as due to paucity of time, I will be referring to some of them. Had to remark, which have had a lot of impact as far as Pakistan's legal order is concerned. Very recently, the Supreme Court took upon itself the task of announcing or determining the date of elections, notwithstanding that this is the domain of the Election Commission of Pakistan. In this regard, Supreme Court went on to render almost 2-3 decisions, one after the other. In one decision, they said that it is the governor of a province who is to announce the date of elections. In another, it was said, no, it is the President of Pakistan who will announce the date of elections. Yet, in another decision, they announced the date of elections themselves. And lastly, in the last decision, Supreme Court held that this is not our jurisdiction. And since all the parties here have agreed and they have arrived at a consensus that the elections are now to take place in February of 2024, so let the elections be held in 2024. So this is a total chaotic situation, that we have an election commission mandated with the responsibility of holding free and fair elections, but the matter is to be decided by judges through multiple decisions, and even within their own decisions, they are all inconsistent decisions, conflicting decisions. And in a similar situation earlier, certain like-minded, the word like-minded judges is a new term to our jurisprudence, and this term like-minded judges developed when our last Chief Justice, I would not name him because I want that now that he has retired, he should relax. We don't want to burden him unnecessarily, and I wish him well. But since we are here talking with regard to the jurisprudence that was developed, so our friend, the former Chief Justice, what he did was that he, with impunity, constituted benches of his choice. Those judges were known to all and sundry like-minded judges. After all, why do we have like-minded judges? Why can't we tolerate difference of opinion? Why can't we resolve our differences? Or why can't we have 2-3 opinions and let it be decided by the majority? There can be 2 reasons for this. Either the person forming the benches has an authoritarian mind, or he has some conscience which is perhaps whimsical, or there may be something more to it which I may not dilate further. But it is extremely unfortunate that we pass through a very sad period in Pakistan's history where the Chief Justice solely had hijacked the entire court and subjugated the Supreme Court, even the brother judges had to remark in their orders that this is not the way that benches should be constituted. Rather, benches should be constituted with a consensus of senior judges, and eventually a law had to be brought in, and that was the Practice and Procedure Act of 2023. And we see that in this process, Pakistan's largest province, the Punjab, the government of Punjab was overthrown by the like-minded judges by rewriting the constitution, in which they held that the election that was held of the Chief Minister of Punjab, the votes of those who defected will not be counted, whereas Constitution doesn't say so. Constitution only says that anybody who defects will lose his seat, but nowhere it says that votes will not be counted. In any case, the Punjab government this way was overthrown. So this was the second instance. First one was about the date of election. Second is that the Punjab government was overthrown by such decision, which was not only conflicting with Supreme Court's own decisions, but it was in direct conflict with the Constitution of Pakistan. And during these proceedings, judges were afforded a chance to dispel such notions that these matters should be referred to a full court, for which there was a nationwide demand, but this demand was brushed aside by the great like-minded judges, by means of a highly defective reasoning unknown to jurisprudence of any age or any period. Now, likewise, when a new law came in that like-minded judges' benches should not be formed, this law was legislated, and that was the Practice and Procedure Act. Supreme Court, through like-minded judges, the then Chief Justice, suspended the Practice and Procedure Act, and while he remained Chief Justice, that law remained in limbo, but it became operative after he was gone, and later on the Supreme Court upheld the Practice and Procedure Act. It is not a very complicated matter at all. All that the law said was that instead of one Chief Justice constituting benches of his choice, the law wanted to empower more judges, or rather the Supreme Court, to constitute benches. But the like-minded judges thought that this was against the independence of judiciary. How could anything be against the independence of judiciary, which empowers more judges rather than one Chief Justice? Because Supreme Court consists not only of Chief Justice, it consists of Chief Justice and other judges. I mean, these were blatant violations of law, which do not require very lengthy reasoning, which do not require lots of references from law books, which on the face of it was illegal, and this was most unfortunate. And then we come to a very recent case, which is probably still going on, and that was the controversial decision of like-minded judges in the matter of trials of civilians by the military. Now, Constitution nowhere says that civilians can't be tried by the judiciary. In fact, there is an article in the Constitution which says that all the military laws are exempt from the operation of fundamental rights. But to declare all this unconstitutional, the like-minded judges took several months, hundreds of hearings. Anything which is declared unconstitutional can be seen maximum maybe in one hearing, two hearings, three hearings, four hearings, not in scores of hearings, that an effort is made to declare a law to be unconstitutional, because the basic principle of declaring a law unconstitutional is that as far as possible, an effort will be made to reconcile the Constitution with a law which is sought to be declared unconstitutional. Instead of making such an effort, in fact, there was no need for such an effort. On the contrary, effort was being made for several months that how to declare it unconstitutional, and it was declared unconstitutional, and now the matter is in appeal, and there's a different view now, and Supreme Court has suspended the order passed by the like-minded judges. And these are some of the few cases of conflicting decisions. Now, if I go further, there are many more. In Pakistan, I won't be able to talk on each and every decision because there are many. But some of the very basic decisions that I think I must share with you. The one such decision was judgment of 31st of July 2009. That is unique in world's legal history, that where a Chief Justice gets restored and he constitutes a bench of his own choice, picking up 13 judges later appointed afterwards, and 14 judges of Supreme Court oust 15 judges of the Supreme Court. And those 15 judges, most of them were constitutional judges. And these 14 judges, they were all PCO judges. They had taken oath under the PCO of General Musharraf. And still, they had the cheek to oust the constitutional judges and declare the constitutional judges to be PCO judges, which was absolutely against facts. But this happened in Pakistan. It was like a broad daylight robbery. I was also one of the judges who was thrown out then. But I don't hold that against them because I don't think I was affected by that. But Pakistan's jurisprudence was affected. That entire judiciary was uprooted by the restored Chief Justice and his group of judges, and 14 judges ousting around 70 judges of Pakistan's judiciary. And in that decision, those judges were not a party to the proceedings. They were never heard. And since all of you belong to this legal fraternity, most of you, all of you know it so well that a decision which is rendered without hearing somebody or against a person who is not a party, all over the world, such decisions are called void ab initio decisions. And I today strongly feel that that was a void ab initio decision. In that decision, the subsequent restoration of Chief Justice was declared legal and constitutional, which in fact was neither by means of any law nor by the Constitution, but that restoration of Chief Justice was the result of executive order made by the Prime Minister at the floor of the House. There was no backing of law or the Constitution, and all those subsequent appointments were illegal. But in any case, much time has gone, and I am not saying that now, after so much time, we should revisit that in such a manner that we should now turn the system of justice, whatever is left, in a completely chaotic state. So I'm not saying that, but I'm just highlighting that what kind of decisions were rendered. And as far as this judgment of 31st July is concerned, it was a decision in conflict with Zafar Ali Shah's case. In Zafar Ali Shah's case, some of these judges themselves held that whenever there is intervention by the armed forces, and that intervention is for the welfare of the people, because now the law of necessity was changed, and the reasoning in Zafar Ali Shah case was based on principle of salus populi suprema lex, that welfare of the people is supreme law. In other words, this judgment of 31st of July was not only a departure to Zafar Ali Shah's case, but this judgment of 31st of July was total antithesis, and it was Zafar Ali Shah case also, and this judgment also. They were, I would say, Zafar Ali Shah case especially was again an old wine in new bottle, wherein Maulvi Tamizuddin's case, the then Federal Court or Supreme Court, they held that they based their decision on law of necessity. Here, law of necessity was changed into salus populi suprema lex, which was just old wine in new bottle, nothing new. And so this decision of 31st of July is the basis of legitimacy of the present judiciary. which is most unfortunate. And lately they have been revisiting some of their judgments. And I would say that this judgment also would be revisited in the coming days so that the Supreme Court make its slate clean. Another very important case in these matters was the NRO case, National Reconciliation Ordinance of 2007. And this was a law which was declared unconstitutional by a Supreme Court at a time when the law had already expired, but it was resuscitated through fiction. A law which came to an end by the fiction of Supreme Court, it was resuscitated saying that it will continue for another 1 year till the Supreme Court completes its hearing and then declares it's unconstitutional. Otherwise, that matter had become infructuous. There are many other cases of this kind. We have the 18th Amendment case. We have another case of the Prosecutor General of National Accountability, absolutely illegal decision. Then we have judgment of 54 bureaucrats who were posted around 2010-11, and their appointments were declared illegal. They weren't even a party to these proceedings. Then the court started appointing their own chairman of the National Accountability Bureau. 2 chairmen were ousted by the court, one after the other. And all these unfortunate decisions have led to a very chaotic jurisprudence in Pakistan. And very recently, we have 2 cases, very interesting. One is the Nasla Tower case, and the other is the Constitution Avenue 1 case. In Nasla Tower case, it was decided that since the construction was on the land which was not legally owned at that time, or where there were certain violation of laws taking place, so they did not have any regard for a bona fide purchaser without notice who had purchased those apartments. But the ego of the Chief Justice, whatever the yardstick was then, all that was declared illegal, and Nasla Tower was pulled down. Whereas in the matter of Constitution Avenue 1, almost on similar facts, it was not pulled down. Rather, they said that it needs to be regularized, and that building was regularized. Now, these are 2 conflicting decisions which will continue to haunt some of our judges, especially those judges who were also a part of Nasla Tower case and also a part of the Constitution Avenue 1 case. Then the most important cases in this ambit are firstly the lifetime disqualification of Prime Minister of Pakistan, Mian Nawaz Sharif, and then a totally opposite decision in the opposite direction, and that was the reversal of lifetime disqualification by the Supreme Court of Pakistan. So on one hand, Supreme Court disqualified a Prime Minister, overthrew a sitting government, the entire cabinet was sent packing home. On the other hand, after several years, the Supreme Court came to the conclusion that this lifetime disqualification is not countenanced by the Constitution, and that has also happened very recently. And not only that while disqualifying the then Prime Minister Nawaz Sharif, they went on even to hold that he should be tried by NAB for his unexplained assets, and he was tried by NAB by constitution of a JIT. And what was the result? The result was the Prime Minister was convicted, but eventually he was acquitted. Therefore, the entire exercise was illegal or uncalled for. So there's a complete silence as regards to that now, what is to be done now. And apart from that, another very important case which preceded this Mian Nawaz Sharif's overthrow, another government was overthrown in the year 2012. The then Prime Minister Yusuf Raza Gilani was held guilty of contempt of court. Yusuf Raza Gilani was held guilty of contempt of court and resultantly was disqualified. He was disqualified, but now he's the chairman of the Senate, and that decision was absolutely incorrect. So, having given you some crux and gist of these conflicting decisions in Pakistan's judicial history, especially by the Supreme Court. I think I would not go on further with all this because the today I have so many cases in my mind that if I start continuing on this, it might take another hour. So I don't want to take your time because there are other speakers also. So now I would just get to the point straight, and that is that what is the solution after so much havoc and mess has been created by these conflicting decisions? In my humble estimation, I would say that there's an immediate need for a constitutional package, and that constitutional package must ensure that strict trichotomy of powers should be preserved and the supremacy of the parliament should be preserved, and obviously parliament is the mother of all laws. Then we must ensure zero interference in the matters of executive and other organs of the state. Likewise, other organs should also not interfere in the matters of judiciary, and we must empower the Supreme Court in a manner in which no Chief Justice or no group of judges can subjugate the entire Supreme Court. And lastly, we need to strengthen the Election Commission of Pakistan, that whenever the elections are underway or are being held, Supreme Court stays its hands off, that there should be no interference from courts in the matters of Election Commission. These are some of the very basic things that they are to be done as immediately in the next few months on priority basis. Yes, this is my wishful thinking, but this can also happen. Thank you very much for a very patient hearing. Thank you.
Thank you, Irfan Saab. I think Irfan Saab has laid down, has talked about the Pakistan experience and has talked about it with great clarity and representative examples. So I think now the question to all of the panelists, which forms the overarching theme of this conversation, which is when we talk about conflicting, because Irfan Saab talked about conflicting decisions and, to quote him, the havoc that they've wreaked, and which is true, which is true in the Pakistani context, most certainly, as he said. But the idea, and the idea that consistency is an imperative in itself, is an end in itself. The judges should always be consistent. And we can talk about sort of, in different contexts, we have these debates in the US on reading the Constitution and on originalism and textualism. And I think that needs to be interrogated.
Now, just for an example, I am telling you that Sri Lankan Supreme Court is acting fearlessly at the moment. Once it was decided that the government formed by His Excellency the President was illegal, and that government was dissolved, and then the Supreme Court makes certain decisions against the former Prime Minister, the former President, then the IGP and all, regarding the Easter Sunday attack, saying that they are liable and they were ordered to pay compensation, and I was on that page too. So the Supreme Court fearlessly going into it, but what is the limit? So that is one area.
Inconsistency, what is healthy inconsistency, or which brings stability and which not. And I can begin by the Sri Lankan experience. We were judge of the Sri Lankan, former judge of the Sri Lankan Supreme Court, and I can put the question to you: what's the Sri Lankan experience been? Can you hear me? You can talk. We can do this while sitting down as well, if you want.
Before going into that unnecessary, I think that the one part of this topic, that eroding the rule of law, is one aspect that we have to discuss. If this conflict of judgments is because of the eroding of the law, rule of law, then it becomes very serious. I'm talking from my experience in my country. You see, one issue that the judges are facing in our country at the moment is that the criticism of the judgments of the Supreme Court judges. As His Lordship the Chief Justice said in the morning, the judges have to be prepared for the criticism. I totally agree with that. I totally agree with that. But if it is a constructive criticism, yes, judges will have to accept it and they will have to get themselves corrected if there is anything wrong. But if it is a malicious criticism, what is the situation? Now this comes especially when the criticism is done by a politician in parliament. Now we have some experiences where the parliament is discussing about the Supreme Court judgments. So they are doing this under the parliamentary privileges. So whatever they say, the judges cannot take any action. So then what happened is, if the judges are not prepared to face that criticism, then they will try to make the judgment more softer. So that is one area.
Sir, there seems to be a problem with the microphone, and maybe you can come on the rostrum, or you can have have a
What I say is, the reason for the conflict of judgments is the matter that we have to discuss. Now in my country we have some experience that the judgments of the Supreme Court is criticized by the parliamentarians in the parliament under the privileges of parliament. So once it is done under the privileges of parliament, the court cannot question them because it is their privilege. But then when it happens in that way, what happened to the judges? They don't want to face that unnecessary criticism. Right? They can't take action, they can't answer. So then the following judges may take a different view because of this situation, which has to be prevented. The other thing, when there are criticisms of that nature, the general public will not have, they will not trust the judiciary, or they may not go before the judiciary to get relief, because the judges' decisions are being questioned in the parliament. So this type of situation can create lot of, this can lead to lot of conflict of judgments. That is one area. And as your Lordship said in the morning, if the judiciary is weakened, all the other institutes will be weakened, because the politicians or the people in authority will take action, they will be able to take action against those institutes who are working according to law. So under these circumstances, what I say is that we as judges and you as lawyers and the general public must take an initiative to protect the authority of the judges. once the authority is protected, they will act fearlessly, and then this problem can be solved. Now, just for an example, I am telling you that Sri Lankan Supreme Court is acting fearlessly at the moment. Once it was decided that the government formed by His Excellency the President was illegal, and that government was dissolved, and then the Supreme Court makes certain decisions against the former Prime Minister, the former President, then the IGP and all, regarding the Easter Sunday attack, saying that they are liable and they were ordered to pay compensation, and I was on that bench too. So the Supreme Court fearlessly going into it, but what is the limit? So that is one area that I want to bring to your notice, and I think we should discuss on that also. How long can I take? Yeah. The other, this eroding of law is happening in another way also. Now, in Sri Lanka, we can't have a review on enacted laws. All the review is at the bill status before enacting it. So, in recently there was a act presented for the online safety, and I am the chairman of the Human Rights Commission, and we were very unhappy about it, and we expressed our opinion on that, and the parties filed action in the Supreme Court. The Supreme Court gave a determination saying that certain sections to be amended, but once the act is passed, we found that several sections have not been amended, and it is enacted as per the bill, and we found that it is not in line with the Supreme Court determination. Then we had to write to the Honorable Minister and the Speaker, and the situation is that. So then what happens? Now the Supreme Court determination was to amend it, but the Parliament did not amend it. So the authority is there with the Supreme Court to say that whether this cannot be passed or not. When the Supreme Court says that this cannot be passed only with 2/3 majority, the Parliament passed it with half simple majority. Then in such a situation, how the Supreme Court judges will act, what will their feeling? Now all these things will come into this conflict of judgment. That is why I say that there may be so many reasons for this conflict of judgment. On the other hand, there may be reasons that the certain law had not been presented to the judges and they were ignorant of it. It's a normal thing. It can be rectified by a bigger panel. But these are issues I think we will have to address, and we will see. We'll go on with the discussion. And thank you.
Thank you, sir. And now I'll request Frederik Waage, who's been a former judge of the Danish High Court, is a professor of constitutional law. And I guess the question is similar. The question is the same, right? The balance between consistency and difference of opinion. When does difference of opinion become counterproductive? So.
Thank you very much. I can only say that the themes that we are dealing with here, they're fairly familiar. We deal with the questions also in Danish law about the relationship between parliament and the judiciary, and also the question, can you criticize a judgment from the Supreme Court? Is it something that will contribute to legal uncertainty, or perhaps interference from the parliament, which is which is damaging to the state of law and order. I come from Denmark, which is a country that belongs to the civil law tradition. And now I've learned while being here in Pakistan that the Pakistan legal system is sort of a mixture between common law and civil law, different legal traditions. From a civil law standpoint, I would say that we have courts which are not very active courts. Our judges are not democratically elected and are even not politically appointed directly, as we see it in, for instance, the United States. Our judges are merely technocrats, which are meant to be, as Montesquieu said, the mouth of the act. And what their job is basically to focus exclusively on how to interpret the act as it was meant by the legislator. So all our focus as lawyers is on what Parliament meant when they adopted the Act. And we look very much into the history of the Act, of the travaux préparatoires, of the preparatory work, when we try to interpret the Act. Denmark is also a part of the European Union and the Council of Europe. And in the European Union, we have a European Court of Justice in Luxembourg. They are more sort of a mixture between civil law courts and a common law court. And what we can see there is that we have some partly politically appointed judges, but they are to be totally independent. They sit there for many years, and they are in the sphere of independence because they represent the European Union and not the individual member states which they come from. And if we look at the way activism is performed by the European Court of Justice in Luxembourg, the European Union Court, then I must say that it is a more activistic court than we find in most of the civil law countries. They take their liberties to sometimes come up with some very free elements of interpretation. And that is a part of the tradition, and it can work and also work very well in democratic legal order. But it is something that has developed over time. So the fact that the European Court of Justice in Luxembourg are now allowed to be rather free in their interpretation, you can say activistic, is partly due to the fact that we have a long history of development of European Union law. In the very beginning, the European Union was basically a union which dealt with coal and steel and stuff like that, something that was not close to people's lives. But over the years, the European Union has developed, and now European law is very much interfering in the life of all Europeans, all the Europeans from the member states of the European Union. It took merely 60 years to get there. And that means that the first judgments which came, they dealt with coal and steel. They dealt with business law. They did not directly interfere in people's lives. And over many years, the European Court of Justice got recognized for making these judgments. And to the degree that the European Union did not agree upon this, then the European institutions, including the European Parliament, the European Commission, they could alter the European law in criticism of the court. So there's been an interplay there. So just to say that, in my understanding, at least from this question about judicial activism, it's very important to have these independent institutions which are respected. And that respect is something you earn over time when it comes to law, or at least you have to be totally sure that these institutions have their freedom. If I finally may address the cooperation between the courts and the parliament, I think it's at least from a Danish civil law point of view, considered a part of the balance of power very necessary to be aware of, where you take the political decisions and you take the political decisions in the parliament, and where you make legal decisions. And while the Danish Supreme Court has sometimes been, in a very limited way, activistic, it's not their job to be politicians. But that is because they are not democratically elected in Denmark. It's not even that they are appointed by the president. We don't have a president, or by the ministers. So the job of the Supreme Court is not to be activistic. That's the difference to, for instance, the United States. And just to name one example, Denmark passed an act in November 2023 about the banning on the burning of holy books. This was a parliamentary decision. It was a political decision to do so. And in my opinion, and I believe in most lawyers' opinion, this was a decision that should be made by the parliament. This was not a decision that should be made by the Supreme Court, because they don't have the mandate, in fact, to make political decisions. So out of a democratic process, the majority of parliament, they adopted this act. In a civil law society, it would be very difficult to make controversial political decisions, as we see it in the United States, for instance, in the abortion issues, with their acts dealing and giving up old practices regarding that issue. It's just not the main understanding we have in civil law. But to sum up, to be able to be activistic courts and to be able to be respected, in my opinion, it's something you need to earn over a period of time, where you gradually ensures people that you have the respect, you have the independence to perform that task. Thank you very much.
Thank you. And now I'd ask Mr. Salahuddin to come and speak. And I mean, of course, he can speak about the Pakistan experience, given his involvement in the seminal political cases, or cases where we've seen difference of opinions or polarization.
Thank you. It's a pleasure to be here at the Asma Jahangir conference again. The topic at hand is contradictory decisions. I was reminded of an interview of the late Zulfikar Ali Bhutto, Prime Minister of Pakistan, with an Italian journalist, Oriana Fallaci, who asked him why he made so many contradictory statements. And he, in reply, he quoted the American philosopher, essayist, Ralph Waldo Emerson, that a foolish consistency is the hobgoblin of little minds. The full quote of Emerson runs that it is the hobgoblin of little minds, adored by little statesmen and philosophers and divines. With consistency, a great soul has simply nothing to do. He may as well concern himself with his shadow on the wall. Speak what you think now in hard words, and speak tomorrow what tomorrow thinks in equally hard words, although it contradict everything you say today. Now, another Prime Minister of Pakistan expressed a similar view, with perhaps a little less flair, that a leader who does not take U-turns is no leader at all. Now, like politicians, poets are also similarly untroubled with contradictions. Rather, they embrace that conflict within themselves and they make it a fertile field for their creative expression. as anyone who tries to pigeonhole the ideology of Allama Iqbal from his poetry. Now, perhaps the American poet Walt Whitman put it best, that do I contradict myself? Well then, I contradict myself. I am large, I contain multitudes. Now the question is, do we want our judges to be great men, or do we want them to be little men, hemmed in and locked in by the law? Are we willing to give them the same creative license that we are willing to afford poets or political leaders? Are we right to demand a greater consistency from them, a greater logic from them? That is what we are here to discuss today. Now, starting from the topic, which is eroding the rule of law and conflicting legal decisions, first let's pass the rule of law a little bit. Now, the rule of law has many components and we can't possibly go into them here. There was an excellent article the other day I read by Rima Umar in which she encapsulates 8 components of the rule of law. Now, one of them is consistency. Now, there should be consistency in the law itself and necessity and of supreme public welfare to justify military rule. The Supreme Court took a step forward. It was a conflict. It was a positive conflict. Similarly, when the Supreme Court today has struck down military courts, which earlier it had said trials of civilians in military courts is okay, when it took the step that no, it's not okay, FB was wrongly decided, I think that is a positive development. The problem is that you have to squarely confront the previous jurisprudence. The problem arises when the Supreme Court does not face up to the previous jurisprudence. It just ignores earlier judgment. Requires a certain degree of cooperation and self-restraint from judges as a group. They are responsible for interpreting laws and they are responsible for applying those laws. For us to have any kind of consistency in both the law and the application of law, they have to be willing to sacrifice their individual creative impulses in favor of collective certainty. That over your hands to be tied by past legal precedent and sometimes being forced to reach decisions that go against your personal sense of morality, right or wrong, or even justice. Now, a poet who lets his individual expression be hemmed in that way, now that would be a mediocre poet. But a judge who lacks the self-discipline to do exactly that, that judge is in the wrong profession. Now, don't get me wrong, I'm not advocating that there should be an absolute rigid adherence to past legal precedents. Something that allows for no room for creation of new jurisprudence. At one level, conflict, dissent, these are essential, these are the fields from which judicial progress, jurisprudential progress happens. If we just all faithfully followed precedents, it would condemn our todays and tomorrows to the clutches of the dead hand of the past. But nonetheless, there are good conflicts and there are bad conflicts. I'd like to talk about those a little. Now, firstly, the good conflicts. There is the healthy conflict that takes place within a judicial decision itself, where judges on a bench disagree or dissent with a conclusion owing to different interpretations of the law. This kind of conflict only stimulates a deeper and more holistic understanding of the law, and it allows the jurisprudence to move forward. A classic example perhaps is the decision of the Supreme Court in the 21st Amendment case. Now there was a question whether the Parliament has the right to form military courts through a constitutional amendment, which would try civilians accused of terrorism. Now, as a democratic constitutionalist, it was a very, very difficult question to answer. On the one hand, the petitioners were saying that the Supreme Court should strike down a constitutional amendment passed by 2/3 of both houses of parliament. Now, that is something that any constitutionalist grapples with. Why should judges get to strike down the will of parliament, especially in a constitutional amendment? But the other issue was equally grave. Military courts. Now, military courts, it is said, are to the concept of justice that just like military bands are to the idea of music. They are an assault on the senses. Now, how can you reconcile the two? Now, predictably, the Supreme Court had 4 different views that came forward in that judgment. 17 judges heard it. Some of them went and said, 5 of them said that you cannot have military courts, and we are prepared to strike down a constitutional amendment in that. 3 of them said that no, Parliament's will must be respected, and we cannot strike down its constitutional amendment. 8 of them took a middle line. They said that we can perhaps strike down some constitutional amendments, but this case doesn't qualify so long as the Supreme Court retains the right of judicial review over any decision that the military court passes. So, and then there was a 4th view, and that was the view canvassed by Asma Jahangir Sahiba, and she took the line that which was accepted by Justice Afsar Saeed Khosa, and that was the position that although the Supreme Court cannot strike down a constitutional amendment, nonetheless there were technical defects in the amendments to the Army Act which made those military courts defective and inoperable. Now, these were attempts, genuine attempts, to grapple with a serious constitutional question. Now, that kind of dissent is very healthy. The second type of good conflict is when judges move on with the changing times. Now, in the US jurisprudence, the classical example is Plessy versus Ferguson, where the US Supreme Court said that racial segregation is constitutional. And then much later, in Brown versus Board of Education, they said, no, racial segregation is unconstitutional. The judiciary should move with the times, and they should grapple with these questions all the time. In our context, and I would differ respectfully with Mr. Irfan Qadir on that point, I think the Sindh High Court Bar Association judgment, to the extent that it laid to rest the previous doctrines of necessity and of supreme public welfare to justify military rule, the Supreme Court took a step forward. It was a conflict. It was a positive conflict. Similarly, when the Supreme Court today has struck down military courts, which earlier it had said trials of civilians in military courts is okay, when it took the step that no, it's not okay, FBLE was wrongly decided, I think that is a positive development. The problem is that you have to squarely confront the previous jurisprudence. The problem arises when the Supreme Court does not face up to the previous jurisprudence. It just ignores earlier judgments and chooses to render a new outcome in a different case. There, it then just depends on the litigant and the judges at hand. And you have numerous examples of that. And I think Mr. Irfan Qadir has referred to several of those examples, so I won't bore you with those. Now, the way judges get around these conflicts is by simply pretending that they don't exist. They either ignore the earlier precedent or they call the earlier precedent distinguishable. Now, on a few rare occasions, earlier precedents are actually distinguishable on some principle of law or some distinguishing fact. But a lot of times, the distinguishing feature is merely different judges sitting on a bench, or a different litigant, or a different desired outcome. There is no actual distinguishing feature involved. It is, I'll just wrap up. Hi. The main point of distinction seems to be that in that case, the petitioner was wearing a red hat, and in this case, the petitioner is wearing a blue handkerchief. And then it really makes no difference to the result at all, to any kind of logic at all, but the outcome is completely changed. And so if you somehow land up with a litigant who is wearing a red handkerchief, you don't know whether he falls in the first category because it is red or in the second category because it is a handkerchief. Your result depends entirely on the mood and the whim of the judge concerned. So that is the kind of conflict which changes the rule of law into the rule of men. Now, what our judges must show is both discipline and courage. Discipline to follow precedents, even if they don't like the eventual outcome in the case. And courage that in case they genuinely consider an earlier precedent to be mistaken and outdated, then don't ignore it, don't distinguish it, face it and overrule it, face all the legal issues involved and overrule it. Our Supreme Court has gone even to the extent, and Irfan Qadir Saab mentioned the Punjab Assembly case. In the Punjab Assembly case, the Supreme Court said that even if the issue was whether the votes of parliamentarians should be cast as per the direction of the party head, in a previous judgment they had said it must be cast per the directions of party heads. In the second case, they said, no, it has to be as per the parliamentary leader. And when pointed out that a larger bench had given a different decision, they said, well, if we unconsciously signed a judgment that was wrong, we can now consciously correct the same. Now, that is no logic. That is the issue that the Supreme Court must confront to end the conflict. Thank you very much.
Thank you, Barrister Salahuddin, for very eloquent speech. And I think to the other remaining two panelists, I'm really sorry, I'll just have to say that we just have a short paucity of time, partly because the hall is needed and partly because, primarily because the schedule was thrown off a bit because we started late, but I now invite Diego to come and speak. And you'll also get to hear Diego in greater detail tomorrow, where he does a presentation, and then Sulema.
Assalamualaikum. Okay, now it's working. So, many think that the rule of law is currently in a decline because autocracies are penetrating our societies and somehow they are winning, and they do not believe that the power should be limited. And the truth is that there are a lot of groups and a lot of ideologies that do not believe on the rule of law. They believe on the rule of force. They believe on the rule of ideology. They believe on the rule of a family. And that's true. That is a constant conflict between the rule of law and the rule of force. And that's part of our history, and this conflict will continue going on. But it's my belief that only through the rule of law we can promote peace, we can promote freedom, and we can promote human dignity. And this idea or this view of the rule of law is really universal. I'm really happy to be here in Lahore, in a very different country where I come from. I'm from Spain. I'm from a totally different culture. But I think this is universal value. And a rule of law, in order to be so, needs to be anthropocentric. And what does anthropocentric mean? It means that it has to be based on human dignity. Because if we don't, if it is just a formal set of rules not based in human dignity, we are not really under the rule of law. We are under a different regime. During the opening, I was reading one of the quotes that it was at the panel that was mentioned by Asma Jahangir, the person we are celebrating here. And it said, democracy is not just about election, it is about the protection of human rights. And I totally agree with that, because maybe this could be controversial, but if I had to choose between electing the government and having human rights, I would prefer to live under human rights. I didn't have the chance to meet the person, the hero we are celebrating today, but it was mentioned, justice during the opening, was mentioned that he was some sort of Ruth Bader Ginsburg, a justice of the Supreme Court. And I totally agree that if the Asma had been born in the United States, there would be films and there would be documentaries about her, just as Justice Ruth Bader Ginsburg. I didn't meet Asma, but I have to say I met personally Ruth Bader Ginsburg, the Justice of the Supreme Court. It was in Washington, at the American Bar Association. And I had the opportunity to have dinner with her, and more people, of course, at the very famous hotel for a wide different reasons, that is the Watergate Hotel. And during the conversation, he said exactly something very similar. We were talking about the rule of law, and he said, well, stop a second. He was very kind, but very, very brave at the same time. Stop a second about talking about rule of law. If it's not based on human dignity, we are not under the rule of law. And that really had a great impact on myself, and I preach about it all the time, and I think also Asma Jahangir will think something similar. Because this rule of law, anthropocentric and universal, is my belief, is one of the greatest achievements of humankind. Truly, I believe that. And we should have to come back to the Greek, to the Romans, but also here, to Lahore, a very famous city and with more than 2,000 years of history. And what does the rule of law needs? Because at least in my view, sometimes we can incur in the mistake of being very elite and only for academics. And some people were referring before, no? Common people may not really understand what are we talking about. And that's why we need heroes. And we need great storytellings. And here we have a woman that has a great storytelling, a great hero. And that's why we are here. I'm on behalf of the World Jurists Association, came from Madrid yesterday, only to celebrate this hero and also to make awareness not only in your country, that I think looking at so many people that came here these days does not need to make further awareness, but we should make a further awareness of her legacy throughout the world. And we are really looking forward to do that with you guys, and that her story is known worldwide. Thank you. Okay. Well, bearing in mind just that as I said before, in my view, rule of law is a universal value. It's not only a Western issue. It's not only something from the United States, from England, or from the European Union. I might totally understand that it's worldwide, and anywhere where there is a human being, rule of law, it should be defended and should be promoted. As Earl Warren, the Chief Justice of the Supreme Court, said during the first World Law Congress of the World Jurists Association in Athens in 1963, and I'm going to quote, "There is still hope that humanity will live in peace and freedom if, and only if, we all accept a world ruled by laws, not by force, ideology, a party, or an autocrat. That world is still achievable and requests our faith, work, and loyal commitment." This extraordinary man said these words in the first World Law Congress during the Cold War years, where two systems were not only confronting politically or internationally, total annihilation of humankind was a possibility. As a matter of fact, it was the year of the Cuban Missile Crisis, where humans were really, really close to be totally annihilated from the earth. So I think this quote is extremely important this is an important message I wanted to share with you about the rule of law. And focusing now on the judiciary, one of the themes we are discussing here, in my view, judges are the weakest power of any system, of any architectural system. Why? Because, and we have a lot of them here. A lot of times they are really alone, and they suffer a lot of pressure from political parties, from wealthy companies, and from a wide variety of groups that what they really believe is underneath is that the power should not be limited. Who is a law to limit real power? And that's why sometimes they actually don't like independent judges. And it's my belief that any institutional architecture should really focus on that, on protecting the independence of judges. Not only here in Lahore, but also in Washington, in Brussels, in Madrid, in El Cairo, in Nairobi, anywhere. They need us. They need protection. And coming back to the rule of law, and is basically, I understand that this is really the last tool that the weakest, the poorest people of any society have. The possibility to go to a judge and to ask that their rights can be respected. They can be implemented, irrespective of who is infringing that right. And yes, our last World Law Congress of the World Jurists Association took place at the United Nations in New York. And I was walking around after very, very strong work, like the guys you are here, focused on the organization. I want to thank you all for your work. And after being at the United Nations with so many leaders, politicians from all over the world, I was walking around really exhausted for the Congress, and I came right next to the New York Supreme Court, and there was a inscription in this 150 years old building that said, "The true administration of justice is the firmest pillar of good government." And it really struck me, because you may have a good economy, you may have good infrastructure, you may have other things, but if you don't have really an independent judges, if you don't have a true justice administration, you will never have a good government, and without a good government, common life is extremely difficult and painful. So thank you very much, everybody. All the best.
Good afternoon, ladies and gentlemen. I'm going to speak very, very briefly because we are really running out of time. We have heard a lot about Pakistan today from very eminent panelists. So I'm going to comment not about the sort of higher constitutional decisions, which we have heard in detail about, but the mundane, the everyday decisions where there are conflicts and which present problems for legal practitioners like me. So when I say that as a lawyer, my job is to advise my clients, and the problem that I have with conflicting judicial decisions is that I cannot function in that job because I am not able to advise my clients. As Alauddin said,
It's published as well. Currently working at the AIG prisons at the Home Department of the Government of Sindh. He is responsible for a wide variety of changes within the prison systems, which we are very anxious and looking forward to hearing today. Dr. Qadir would like to welcome you to the panel. And last, I'd like to invite Mr. Javed Mahmood, who has worked as the Office of the United Nations of the High Commissioner for Human Rights in Geneva since 2008. He is the Human Rights Officer lead of the implementation of the UN Commission position on incarceration. He also advises on drug policy and human rights. He represents the OHCHR, the UN Commission on Crime Prevention and Criminal Justice in Vienna. He is also a member of the UN Task Force on Drug-Related Matters.
Not. So when people can't even be certain of their status, that is a system of chaos. It is not a judicial system. So for example, in the High Court, we have judgments where the judges have said, and it's even in the Supreme Court, that for a woman to be divorced, she must have had notice that her husband has petitioned or, whatever, applied for divorce. Because obviously you cannot be divorced if you don't have notice. So I'll say, well, I don't know what my status is.
To the stage.
But somebody comes and says to me, well, actually, you're divorced. So that judgment makes absolute sense. But another judge comes along and says, no, this is against Islamic rules, and you do not have to notify your wife that you are divorcing her. So you can just divorce her in secret, and then she will find out that she's divorced. So if I can't even advise someone about this status, then that is really chaos. So these cases have cropped up, for example, in cases of inheritance, where what has happened is that a wife says, well, my husband has died, and therefore I inherit some of his property as per the rules. And the family members say, well, actually, he divorced you, but in secret. So you can't inherit everything, so get lost. And one judge says, well, this is wrong, and she does inherit something. Even if he has divorced her, he had to notify her. Without notification, she's not divorced. But then another judge comes along and says, well, this is against Islamic rules, so she is divorced, even if she didn't know about it, so she doesn't inherit anything. So these are judgments in family law, which I think create a lot of problem for lawyers. We have other judgments, for example, in child abduction cases, where the Supreme Court says, where a child is abducted, he or she, that child has to be returned to their country of habitual residence. But then the High Court comes along and says, well, no, I think that if the father gets a guardianship order for this child, then we can make that decision. So it runs completely contrary to what the Supreme Court has said. And, this is the problem. We don't have to go to constitutional cases. These kind of conflicting judgments are impacting women and children and, of course, men every day, in everyday life. And I think this is the problem that we face on a mundane level as legal practitioners. And I hope that the Superior Court is very busy in very eminent judgments, but I hope that they will also give some guidance on family court judgments, and because these are things that impact people a lot more than just the business of the state. So I hope that we will get some further guidance from the Supreme Court in appropriate cases, because really there is no attention paid to this part of the law, and this is where women and children suffer the most. Thank you very much.